to finish off Actavis 3 first. I was then intending to move on to normal infringement, grounds of appeal 1, 2, 3 and 4, which can be dealt with fairly swiftly. I was then going to move on, because it deals with infringement, to my respondent's notice on the lobe functionality, which effectively goes to the Actavis 1 finding. And because it was separate, finally I was going to deal with the Grumshausen anticipation and then costs. Now, on each of the normal infringement, lobe functionality and Grumshausen submissions, I will be making one reference each to the unagreed bundle. I'd ask your lordships to hear that effectively de bene essay, because the relevance of my reference will become clear from context, but I don't really want my learned friend sort of interrupting me to make the point at that time.
I mean, he put down his marker yesterday.
All right.
We'll look at the materials de bene essay as you suggest, and Mr. Campbell can come back in.
All right. So let's start then with the Actavis 3. Now, the reason I'm pushing the fact that Actavis 3 in and of itself ought to be a balancing exercise, at least, and or something in which effectively the burden initially arises with the patentee, because it's the patentee who drafted the patent, is really the very strong way my learned friend makes the contrary point 3 times in his skeleton. And he says, and I'm just going to read them to you, he says, there must be something more. I'm told the transcript isn't working. Do you want me to stop or carry on?
I assume it's still being recorded so that transcribers can catch up later.
If I say something relevant, you can get it if necessary. All right, I'll carry on. My learned friend says, firstly, there must be something more, some further indication in the patent. He then says, the Actavis 3rd question asks for a positive reason. And in para 91 of his skeleton, it is necessary, responsive skeleton, it is necessary to find a reason why the scope of protection should not, and I think he underlines the word, extend to the variant. And I say, if that is the approach, that would not provide the balance of the protocol, which is to give due accounts to equivalence. I've taken you through my catnic submissions yesterday. I'm not going to repeat them. I'm just going to make one more point on this. The protocol is to give due account to equivalence. If one gets through Actavis 1 and Actavis 2, i.e. it works in the same way to achieve the same purpose, if you pass Actavis 1 and Actavis 2, you qualify as an equivalent. That's what makes you an equivalent, to get through Actavis 1 and Actavis 2. At that point, you are entitled to have due account given to you. And the due account is the balance of the protocol, not a starting assumption that because you're an equivalent, you must infringe. And that's really how I put it there. I do say, and I'll come to it in a moment, that is precisely what, well, maybe it's not, he knows better than my submission is that's what Lord Justice Arnold did for his final reason in Akebia, and we'll come to that in a moment when he looked at Actavis 3. So I'm going to move to the, and I hope I'm not mispronouncing it, the Akebia case, which is a decision of Lord Justice Arnold, but sitting at first instance. And it's to be found in the bundles at tab 4. Now, this was a a long and complex patent case concerning a pharmaceutical patent. There's a very cut down version of the decision, but it needs to, if I tried to explain the technology to you, firstly, I would get it wrong because I'm not a chemist, and secondly, it would take me the rest of my time. But I am going to pick the case up at paragraph 73 of the page 73 of the decision, and the beginning of the infringement by equivalence. Now, as I understood it, the claim in issue, despite being labelled 17A, was an unconditional amendment to granted claim 1. So effectively, my understanding is when it got to trial, that was the main independent claim that one was considering. And it was clearly narrower than the overall disclosure of the patent, because otherwise they wouldn't have amended it to make it narrower. And on its face, it was limited to a chemical compound with various benzene rings and things, compound C, that we see reproduced at paragraph 412. And the question was whether an allegedly similar, structurally similar component, because organic molecules have this concept of structure, whether a similar structural molecule was equivalent to it or not. And the learned judge held that it didn't get through Actavis 1, and so it wasn't an equivalent. But nonetheless, he went on to consider equivalence, in part because it might come up when considering validity. So I want to pick it up on, I don't want to go through the findings on Actavis 1 and Actavis 2, but I do want to consider some of the findings on Actavis 3 and what I say the rationale behind them was, and that similar rationale can be employed in this case. And the learned judge sets them out from paragraph 447, and he makes 8 points and then a final unnumbered 9th point. And I'm just going to look at the first 4 and the unnumbered 9th one. And he says the following at 449. So let me actually step back to 448. In the present case, I consider it is clear that the skilled team would conclude that the patentee intended that strict compliance within the normal meaning of compound C was an essential requirement of the invention of Claim 17A for a number of reasons. First, Claim 17A is limited by structure to compound C. On its face, it is not intended to cover anything that works or anything that does so by competing with 2OG, which would be purely functional definitions. Just pausing there, I say the same rationale appears in this case. The claim is clearly limited by structure, and on its face is not intended to cover anything that works in the same way. I do accept, of course, the criticism that that reason on its own is actually doing not much more than saying words is words, and the Supreme Court have told us that's of itself not a legitimate approach. The second reason the judge gave was this at 450. Secondly, read in the context of the specification, the claim is intended to be a narrow one and much narrower than either Formula 1 or Formula 1A or 1D. we say again in the current case, read in the context of the specification, the claim, and let's concentrate now on Claim 8, is clearly intended to be a narrower one because the structure of the specification and of the claims was to have 10 structural narrow claims, not one nice big broad functional one. Thirdly, the reason in Akebia 451, compound C will be understood to be the most promising and best explored of the exemplified components in EP 531. That was the patent. We say again in the instant case, not only are these downwardly extending fingers the most promising and best explored of the exemplified way of practicing the invention, they are indeed the only way of practicing the invention. And then fourthly, and the learned judge cites from a German decision, there is the concept of disclosed but not claimed. And the rationale runs as follows. If you disclose something in your specification, but your claim doesn't include it, the skilled addressee would assume that you hadn't included it for a reason. And the way we say this runs in the instant case is that the optionality of downward is disclosed in the spec, in the specification. It's in a couple of the aspects, and it's in the independent claims that don't include downwardly. So there is a tiny bit of the spec that suggests that downwardly is optional. However, in the asserted claims, 5, 8, 20, it is not claimed as an option. So that's my disclosed but not claimed argument. Finally, the learned judge at 461, although he doesn't put it as a reason, says the following: if finally one cross-checks the foregoing conclusion with the protocol, I consider it's manifest that in extending the scope of protection in the manner contended for would go well beyond the fair protection for the patentee and would not afford a reasonable degree of legal certainty for third parties. So that's what I get on the rationale for some of the reasons given at Akebia and how I say they are relevant to the current case. Let's turn then to the 3 key reasons for strict compliance we say the judge held and that he rightly held. Those 3 reasons are these. Firstly, the patent teaches weld portions that extend away and nothing else. The patentee has chosen this particular way to achieve the intended effect and limits the claims to that. Secondly, the patentee could have drafted a single overall functional claim, but chose instead plural structural claims. And thirdly, disclosed but not claimed, the optionality of downwardly is disclosed in both the discussions of the aspect and in other independent claims, and is not claimed in the independent claims. So looking at those 3 reasons, and I can probably speed up now, and if we turn to the judgment, which is in the core bundle at tab 9, and turning then to 129, perhaps I can just ask your lordships to remind yourself of what 129 says. So, first reason, it teaches these well portions and nothing else. They've chosen this particular way. That's one of the reasons I've gone for it. I don't think I need to say any more about it. Secondly, the patentee could have drafted a single overall functional claim. My learned friend takes issue with the word whether it's straightforward or not. In colloquial terms, really, that's his problem. It's a unilateral statement in words of his own choosing. He could have chosen them differently. In any event, if he wants evidence on patent attorney practice, he should have put it in at trial. And thirdly, the disclosed but not claimed. This is perhaps a slightly hidden reason, but we read the judge that into the final sentence and paraphrase it perhaps like this. It would, for example, have been straightforward for the patentee to formulate a claim by result or to a narrow bag, or to omit the word downwardly, brackets, because the patent discloses omission of the word downwardly as an option, close brackets, but none of the asserted claims do that. So that's where we get the disclosed but not claimed. That's really it on Actavis 3. I'll move now to ground 6 of the appeal. Now, there was an understanding between junior counsel that this was being dropped, consequent upon the reply skeleton, paragraph 15. We asked for confirmation in writing, and basically letters went forwards and backwards, and they refused to give it. It's still not entirely understood by me whether or not it has been dropped. But my submission is this: I don't see how it can possibly run unless the findings as to what the waste, W-A-I-S-T, does, and they haven't made that challenge. I also note Lord Justice Arnold's observation yesterday that the ground of appeal on its wording doesn't actually seem to challenge that findings anyway, despite the fact that both myself and my learned friend have been working on the basis that that's what it did do. So that's all I have to say about ground 6. So I'll move on then to construction. I have a few points on this just before I look at the judgment and say what I understand my learned friends to be doing. And I am also going to look at some of the evidence on this, which is relevant to informing the court as to the alleged function of a structure in circumstances in which the patent doesn't tell you. Firstly, I say this: when considering the purpose, one would assume it should be consistent with the inventive concept. You effectively shouldn't be getting 2 bites of the cherry, with a first equivalence case under normal construction, which is this directing argument, and then a second entirely different equivalence case under the doctrine of equivalence. When one reads my learned friend skeleton, what he actually seems to be trying to do is not construe the words extending away and downwardly, but instead replace those words with a functional requirement. And there is a bit of a sleight of hand there, because having replaced the words of structure in the claim on the basis of this alleged directing functionality, which isn't established by the expert evidence anyway, they then apply that functionality idea to the ModaVi, regardless of the fact that they've no evidence that the ModaVi functions in that way either. So I've said it many times in conference, and I'm not waiving privilege on that. This is completely my dog has, all dogs have 4 legs, my cat has 4 legs, therefore my cat is a dog argument. This is an alleged purpose of extending downwardly is to direct waste. Therefore, it's all about directing waste. Therefore, I can define a direction, and therefore something that has that direction, even if there's no evidence that it directs waste, infringes. There are clear findings in the judgment that the weld portions do not direct waste, or at least there's no finding in the judgment that the weld portions do direct waste. And if my learned friend wanted to get this finding off the ground, he needed to take you to evidence on that, and he hasn't done that. I get that from paragraph 116 of the judgment and 117, and those, I say, are the findings of what the weld portions do. So what the judge holds at 116, halfway through, is the purpose of the welds is to create a space within the periphery of the bag that channels the waste and also makes the bag narrower than it would be without the welds. So he's not holding that they of themselves direct the waste, it's the overall structure that does the channeling. He goes on at 117 to also say they're not downwardly. In my submission, that sentence at 117 might read better simply if one omits the word if as a typo. So further, I am not persuaded that the waste is a weld portion, that it extends downwardly. Maybe I'm wrong on that, towards the bottom of the bag. What I understand the judge to be saying is at 116, I'm considering the purpose and does it extend, and no it doesn't, if it's the waste, W-A-I-S-T, and at 117, and it doesn't go downwardly anyway. The arrows are reasonably self-explanatory. They go through the axis of the deviation, perhaps one could put it that way, and in exactly the same way as in figures 3 and 4. I wanted then to move to figures 3 and 4 of the patent, and this actually also came from a question from my Lord, Mr. Justice Miles. Is the axis as marked in the direction of the axis as marked in figures 3 and 4 effectively the direction that one considers when thinking about what is upwardly and what is downwardly? I think that was your question of yesterday. My answer to that is yes. And I do pray in aid that it is relevant that I asked that question to the defendant's expert, and he effectively said yes as well. And perhaps I should go to that. So that is my one excursion in this ground to the unagreed bundle, and it's at page 187 of the unagreed bundle. It's quite difficult to read the red numbering, but it is page 193 of the transcript. And it is the portion of the cross-examination between, which is the top right in the manuscript. It is the portion of the cross-examination between lines 11 and 23, where effectively I read him the explanation we looked at, and I ask the question, insofar as there's any tie anywhere in this patent between an extension and a direction of extension. We have one here, that is the axis D, which is extending lengthways. Is that correct? And he says yes. Our expert says the same thing. I'm not going to take you to it because it is something you've looked at briefly already, but it's in Anderson First, Para 147H, which is in the supplemental bundle at 99. So to the extent that the expert evidence is admissible or relevant on what is meant by downwardly, the experts were in agreement that it's the axis of the extension as identified in figures 3 and 4. I do want to look then very briefly at what I described possibly pejoratively as sleight of hand. Firstly, there's no evidence in the patent that directs, and secondly, there's no evidence that the lobes of the alleged infringement direct. I can't recall from my note whether we've already looked at Mr. Bree's evidence in chief, which is where one would expect the patentee.
No, we haven't looked at that.
That is at the supplemental bundle at tab, well, at pages 71 and 72, which is tab 5. Just before 71, there was less than a single page explaining from Mr. Bree what he read into the patent. And then at 71 at the bottom, at para 102, he says, given the purpose of the weld portions is to influence the way the bag fills up with waste, there should be some change in direction into the internal chamber of the bag and towards the area where waste is to be collected. For example, the embodiment of the pattern shown in figure 1 shows the weld portions being part of the peripheral weld. That's about it. So if one was expecting the patentee to be saying, well, this concept of directing of waste and sliding down is all very important and is something the skilled addressee would understand from reading, he needed to put it in his evidence, and he hasn't. I'm not going to take you to his second report, where one also doesn't find the evidence, but the reference for that is in the supplemental bundle at 119 and 120. And I'm also not going to take you to something I have already gone through, Miss Anderson's evidence, that it stops waste being trapped, but it's not there to direct waste. What we say the experts did agree upon effectively is a sort of negative definition that you wouldn't have these pointing up because that would trap the waste. So the second part of the sleight of hand on this normal construction is there's no evidence that the lobes direct the waste in this manner. And again, Mr. Bree's evidence in chief, and that's where one would expect to find it if that's what the patentee was advancing, is to be found at page 78 of the supplemental bundle. And this is paragraphs 204 and 205 of his report. Perhaps I can just ask you to read those to yourselves. So really, we say, despite the judge's criticism of Mr. Bree's evidence, that it's not clear how much of it was his own work and how much of it was written by the lawyers and how much by him, I don't even need to go there, because if the patentee wanted to establish these grounds, he needed some evidence for it, and there just isn't any. Conscious of the time then, I shall move on to my respondent's notice and the judge's finding of fact that the lobes do work in the same way as the inventive concept. Now, I only need to go there if I lose on Actavis 3 and or your lordships don't decide that the grounds upon which I won on Actavis 3 are better characterised as being in the inventive concept than Actavis 1. And or if a superior court takes a different view. Anyway, I also accept that in the light of the Iconics case, there is a reluctance to overturn findings of first instance fact. But hear me out just for a minute. I do propose to look at what he did and then outline the key areas where he went wrong, and then look at the evidence in more detail to make good why I say he got wrong. But I want to outline first the legal basis why I say I get off first base. And I put that in two reasons, each of which subcategorise into another two. Firstly, an error of principle. The judge saw fit to interpret the experiments for himself. My learned friend makes that absolutely clear in his reply skeleton. He says, the learned judge saw fit to interpret the experiments for himself and was entitled so to do. And my answer to that is no, he wasn't. And he wasn't for two reasons. Firstly, he disregarded how the experts educated him as to how the experiment should be approached. That is not something a layperson can do. One needs to be educated by the experts as to how to approach these experiments. And I'm going to look at a bit of law on that. And secondly, he disregarded the expert evidence as to what they demonstrated. Now, it may well be in some cases it's legitimate to do the second if you've followed the approach you've been told to follow. Perhaps where the experts disagree, but here we'll see the experts didn't disagree. Secondly, so that's the clear error of principle upon which I rely. Secondly, we get to lack of the internal consistency within the judgment. In short, he summarised what he got from the experiments, and then he did something different. I have no quarrel with his analysis in the earlier sections of his judgment as to what he did on the evidence. Secondly, second lack of consistency is he made absolutely clear that a relative assessment was necessary. Everything was relative, and there was nothing in the patent that really helped you on that. He made it absolutely clear a relative assessment was necessary, and then he didn't make a relative assessment. So that's where I'm going. I need to set out a little bit of law as to whether or not the judge was entitled to interpret the experiments for himself. And I'm going to go to two cases on this. firstly, a relatively old authority, but nonetheless the sort of definitive one on a point of interpretation, and that's the Van der Lely case. And that talks about interpretation of photographs and says while lawyers can read words and interpret them, they may need help on photographs. And we say this is actually not only just photographs, it's photographs of an experiment. Secondly, and more recently, the Thorn security case. And what I get from that is my twin propositions. Firstly, you need to take account of how the experts tell you to approach interpreting experiments. And secondly, you should take into account how the experts themselves actually had interpreted them. I've got in my note, and I know I keep on flagging things up, but if I plunge straight into it, then you won't get why it's relevant. Why do I say this is relevant in what this judge did? What he ultimately did is he looked at water experiments, which is taking the bags and modifications of them and filling them to 75% of their capacity with water. Now, every bag, when you make modifications, the volume will change slightly. And what that means you can do is you can either fill it, for example, with 250 millilitres of water. If you do that, you need to squirrel away in your brain that the relative fill will be different. Or you can fill it to 75%, and if you do that, you have to squirrel away in your brain that there will be a different amount of water there, and it will be either heavier or lighter, and that will affect the behaviour in of itself. Now, both experts agreed that this must be factored in. They disagreed over which they preferred. Mr. Bree liked absolute volumes, and then he factored in that the relative amount was different. And Ms. Anderson preferred relative amounts, and then factored in that the absolute amount would be different. It doesn't matter that they agreed to disagree on that. The fact is the judge didn't factor it in at all. Secondly, they both agreed that we're not talking in this patent or in these claims about urostomy bags, which are filled with liquid. We're talking about colostomy and sometimes ileostomy bags that are filled with solid and semi-solid. And we are agreed, the experts are agreed that that will flow differently to water. And so the water experiments only, and in fact the much better experiments is to use synthetic waste. Now, we did do those experiments, but the judge doesn't look at them. Miss Anderson thought they were very much more useful. Mr. Bree said, because I don't know the recipe you're using for your synthetic waste, and you won't tell me because it's confidential, these experiments are worthless. But again, the disagreement between the experts doesn't matter on this. What matters is they were agreed that water actually isn't a very good model of behaviour when one's looking at colostomy, and you're better off with synthetic waste, and you need to factor that in if you're interpreting a set of photos that are just water. And again, we say the judge didn't do this. Now, the further error of approach, flagging up where I'm going again, is the various modifications and why they were made. Now, what we did is we took a bag with the lobes and the waist. We had one without the waist, one without the lobes, and one without both. Now, as Miss Anderson explained, the purpose that one gets from the ModaVi bag, which is the one in which you removed the waste, is to gain information about how the waste behaves, because it's omitted. It is not to gain information about how the lobes behave. So the purpose of that model is for the person interpreting the experiments to say, but I'm looking at mod B and I'm comparing it with other things, and because it hasn't got a waste, that gives me some information about how the waste behaves. The judge ignored that, and he thought it gave you information about how the lobes behaved, even though the experts had explained that that model wasn't there for that reason. Shall I move on to try and make that good? That's effectively, though, where I'm going on my, I have to say, attack on the judge's conclusion, but not anything, anything else. So, picking up the judgment in the core bundle at tab 9, just have a moment. Oh, yeah. My learned junior said, are you going to go to the authorities? Because you've said you will make it good in your authorities, and I haven't taken you to them. She's absolutely right. So one has learned juniors. So if I can take you first, as I said I would, to the Van der Lely case, which is in the second bundle of authorities at tab 23. This is a House of Lords decision on a patent case from the 1960s. It's one of those
days when the House of Lords would allow you to argue a mechanical patent for more than a month.
I'm not going to ask.
World.
I'm not going to ask for a revision to my time estimate. I was also told those were the days where one started on day one by reading the court the patent.
Sure.
Yes, I think it was May, July, and October. Anyway, it's page 71 of the decision, 600 of the bundle, and it's been redlined. Perhaps I can just ask your lordships to read it. And then moving on to the Thorne decision, which is at the next tab. I've said what I get out of the case. That is at page 632 of the bundle, 58 of para 58 of the report. And again, perhaps I can ask no more than to ask your lordships to read that as well. And it does in my Right. It does, in my submission, fall into 2 points, what one gets from Thorne. And it has often been said that the experts come as teachers. Once the expert have taught the judge what to do and how to do it, it is a legitimate exercise for the judge then to do it for himself, particularly if he's got competing expert views. But Thorne goes a little bit further in my submission, says, although once I've taught you how to read, interpret the experiments, and so you can do it by yourself, you should still give respect to how the experts have interpreted them. But at the end of the day, it is a matter for the judge, and he or she is entitled to discard the expert conclusions, because what's important in expert evidence is the reasons, not the conclusions. But I don't need to go there in detail. So we'll now go back to the judgment. And just as a precursor, perhaps, I'm going to pick it up at paragraph 36. And this point has been made, but it's worth making again. The definitions of bulging and sagging, not terms of art, but insofar as advanced for the purposes of these proceedings, effectively the meaning that the claimant wanted to put on them, bulging is very broad and means to swell outwards. And we say again, well, any bag must swell as it fills. This is the precursor for the fact that it must be some form of relative term. Then at paragraph 49 of the judgment, the judge says that the patent does not explain what forces are acting on the appliance or how the welds work to achieve the result claimed. It appears the inclusion of the weld will narrow the bag, but it's not explained whether that is significant. Then at 49...
We've just looked at 49.
I beg your pardon, I thought I'd just looked at 47. But 49 again makes clear that there's no, well, it's all relative. There's no teaching in the patent as to any absolute requirement as to how one assesses bulging or sagging or anything like that. The point I'm getting out of these early paragraphs is the judge's continued noting of the fact that this was a relative benefit, and it was unclear what that relative benefit, how that relative benefit worked, and really precisely what it was, because that all leads to his conclusion in the last sentence at 52. Even with these explanations, the performance of an appliance of the invention is relative. All of that we are in entire agreement with, and we say that must be right. He then looks at the claims, and I want to step through to the section of the judgment on experiments. So that's paragraph 72 of the judgment. And he introduces this by saying both sides carried out significant numbers of experiments. Secondly, it was agreed there's no standard protocol, though it's conventional to fill bags with water or synthetic fill to see how they perform. The patent contains no measurements or experimental examples against which an alleged infringement can be assessed. So that again is the relative point. He turns first to the Salt's experiments. That's the Claimant's experiments. And what Salt's did is shown in para 75. They carried out experiments on 2 types of bag, and basically they recreated something close to the ModaVi, which is their recreation on the left, and that has lobes and a wasted portion. And then they recreated what they said was one with out lobes and wasted portion, which indeed it was. But what they did is they made the bottom of the bag bigger in order to accommodate that. And the judge noted that because the waste, W-A-I-S-T, has been taken out, it has a greater volume. This is at 76. So when you fill with an equal volume of water, which is what those experiments did, the fill line in the second bag would be lower than in the control. So he got the point that an absolute fill needs to be taken into account. He then looked at the results of those experiments, and that is shown in 77. And these were these outlines in yellow and red. And his conclusion at 79 is that Miss Anderson criticised the preparation of the outlines as potentially inaccurate. In my judgment, it does show the different position at the bottom of the bag, but due to the different nature of the bags, it does not clearly show whether this is significant. What we say he's doing there is effectively dismissing this as being of value as to relative performance. And indeed, he doesn't go on and use it. And we say he's right on that. I'm just in passing going to make a very small digression, because it's something that may or may not come up, or may not have puzzled you, or you may have worked out anyway. The purpose of the lobes, according to us. When the bag fills, the bottom edge pops out, kinks out one way or the other. And the purpose of the lobes, according to us, is to cause it to kink outwardly rather than inwardly toward the body. And that's supposed to make it more comfortable. That's the purpose according to us. And we say this is actually shown in this particular experiment, that one sees that the red one is kinking towards the left, whereas the yellow one is kinking more towards the right. And it answers the question that we have posited many, 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 many times. If the lobes aren't there to do the infringing thing, why are they there? And they're there for this kinking function. And one finds that explained in the Ekin patent and in the PPD and when the inventor gave evidence, etc. So any lurking background, if they're not there to do expansion, what are they to do, is answered. That's our answer. Right, I've done the digression. Second sets of experiments was the filling with plaster of Paris. Now, the experts agreed that that's not industry standard. Our expert thought it was mildly bonkers because it's so much heavier and no one would ever do it. What the judge said is, well, I've looked at them, and insofar as I can see anything, it's not clear that it's significant given the unusual material used. And again, they never come back. And we say the judge was right to disregard those and was right to disregard them for the right reasons. So again, that gets us nowhere. That was basically it on the claimant's case. So one might think we were rather unwise to put in evidence ourselves that proved their case for them, but there we are. The judge then came to our experiments, and he kicked off introducing them at 81. Now, there were a large number that he didn't comment upon, but the ones that he took the photographs from were the photographs of the 75% relative fill bag. So there was also out there but not mentioned in the judgment, and therefore one can assume the judge didn't take it into account. Absolute fills with photographs, and synthetic fills with photographs, but none of them made the cut in the judge's estimation, so we can put them to one side and we don't need to worry about them. As well as taking photographs, we did these X1 and Y1 measurements, which everyone else on the legal team loved, but myself and the judge couldn't stand, but there we are. The judge looks at these and effectively goes, well, there we are then. And again, he doesn't take them into account. So again, we can forget about those. Now, unlike the claimant's experiments, the judge at this stage makes no comment on what he gets from the Pelican experiments. But we say the only ones on the judgment that remain in the game, and we'll come to that, is these 75% fill experiments. The judge then looks at the agreed at where he said the experts got to on all that experimental evidence. And he says this: the experts were largely in agreement with what the experiments show about the effect of the peripheral welds, waist, W-A-I-S-T, and lobes of the various bags. And he sums that up in the 5 paragraphs at 85 to 89. We don't need to look at all of those in great detail, but just whisking through them. 85, he talks about what he thinks the experiment showed as to the functioning of the patent, and that doesn't take us anywhere on the current discussion. At 86, he talks about something called the C-weld. Now, the C-weld, if your lordships haven't worked it out, is an extra piece of structure in our bag that's at the top. And it appears common ground that that does work in the way we say it works, but of course it's not relevant to the question of infringement. 87, he goes back to the plaster moulds, which he's already rejected. At 88, he says the following: Mr. Bree agreed that the weld portions caused pinching folds as the bag filled, and the folds halfway up the ModaVi bag are caused by the attachment to the base plate. He also agreed that the kinks at 5 and 7 o'clock are caused by the lobes. And again, we accept that, but just to give your lordships an idea of what we are talking about. If one turns back to 133, bottom left-hand picture, which is the alleged infringement, your lordships will see effectively there are 2 kinks at the 5 and 7 o'clock position on the lower edge, and that the lower edge seems to be pointing towards the camera, the entirety of the lower edge, which effectively is away from the body. And we say that's entirely consistent with the lobes doing what we said they were there to do, to cause it to kink outwardly rather than inwardly. And it seems that the experts agreed that that was, let's put it this way, a function of the lobes. But that again doesn't take us...
I'm not sure that's right, is it? Because certainly on what the judge says, I mean, I don't know what the evidence was, but the judge merely records agreement that kinks caused by the lobes. But he says nothing about pointing inwardly or outwardly.
I'll take a step back and put it more neutrally then. I've shown you in that photograph at 133, I've identified what he meant by that, i.e. which ones he was talking about. And I will say that is consistent with what I told you about 5 or 10 minutes ago, about it causing it to kink inwardly rather than outwardly. But nonetheless, we don't quarrel with that conclusion as far as it goes, even if perhaps we would like to read it further, but we don't need, we say, to go there. And then finally at 89, in my view, while the experiments are helpful to demonstrate the behaviour of the bags in practice, none of them were decisive on the issue of infringement. Pause there, because when one moves on, he finds them decisive to the issue of infringement. They confirmed what Miss Anderson said about the presence of weld portions leading to a reduction in volume and a weld being placed more centrally. It is hard to draw any significance it is hard to draw conclusions as to the significance of any of these measurements and observations in the context of the patent, because it gives no guidance on what is significant in achieving the invention disclosed. And we say what he does is he goes on and does precisely what he says is hard to do and assesses significance in achieving the invention without applying any form of yardstick that he recites. So at 89, we say at best he gets to a relative assessment. We don't quarrel with 89, but we say we don't quarrel with anything, I don't think, up to 89, but we say it's not what he did. So then we turn to the single paragraph in which he decides this case, were it not for Actavis 3, and that is in paragraph 125. And he says this: the question in respect of the lobes of the ModaVi bag is not easy to determine from the experiments. He's had some expert evidence on this, which he hasn't said. The lobes do appear to have some impact on the way in which the bag expands and holds its shape, although the effect on bulging appears small. Pause there, that hasn't come from any of the experts. There does appear to be some more regularity in Pelican's experimental mod B with lobes as compared with the bags without. Now pause there. Firstly, the mod B isn't there to give you information about the lobes. It's there to give you information about the waste. Secondly, some more regularity. On a water model, not a synthetic model. On a percentage, not an absolute fill, so it will be different. Where is any of this factored in? It isn't, and it has to be. He then goes on and says, comma, and it appears clear that the lobes do have the effect of making the peripheral weld point away from the body. That was the answer to my question from Lord Justice Arnold a little bit earlier. He does conclude this peripheral weld kink function. We agree, we say that's what it's there for, but it's not relevant to the issue of infringement. He then says this, which is unclear. That is in line with the description in Ekin. Now, what is not clear from in that statement is he saying that the effect of making the peripheral weld point away from the body is in line with the description of Ekin, which it plainly is, on the words of Ekin, or is he saying that both effects are in line with the description in Ekin? If it's the former, we're fine with it, but it has nothing to do with infringement, and it shows that he decided infringement solely on one set of experiments. If it's the latter, then we do need to look at Eakin. And again, we say it's wrong, and it's wrong with what he said about Eakin earlier in the judgment, and what the experts said about Eakin, and what Eakin itself says. But it's unclear what he's saying. But I want to park Eakin for the moment. It's not clear whether or not he's doing that, but I will come back to it. So to summarise, before I get into the evidence, I say there are 4 categories of mistake that I have effectively foreshadowed, I hope. Firstly, no single set of experimental results can be determinative. Yet that's what the judge concludes. Secondly, there are swings and roundabouts between absolute fill and relative fill. Even though a relative fill normalizes the results, it creates other problems because you've got a different absolute amount. The experts agree on it. They agree it's a compromise. They agree it needs to be factored in, and the judge ignores it. Third mistake, the water fill does not particularly well model how the bags actually fill when they're colostomy or ileostomy bags. And that really does influence things. And the experts agree on that. But he doesn't factor it in. And fourthly, the ModaVi bag is there to illustrate the effective removal of the waste, not as a comparator for the effect of the lobes. So I'm going to take you through the evidence that makes those 4 mistakes good. We need then to turn to the unagreed bundle, my excursion into it for the purposes of this one. And this is we did ask for this to go in, but we were told no. And my witness, Miss Anderson, my expert, how she explained the relevance of the experiments. And that's at page 63 of the unagreed bundle. Which I now can't find. And perhaps I can ask your lordships to read 247 through to 251, which makes all her points on relative and absolute fill.
We'll do that. Just have a moment. Oh, I'll come back to that. So that's where Miss Anderson is on relative and absolute fill. And Mr. Breen, we'll come to it in a moment, he agrees, but he says it's the other way round. She also introduces the relevance of synthetic fill, and perhaps I can ask your lordships then just to read paragraph 252.
Yeah.
And I think just concentrating on the last line on page 64, the synthetic output experiments are closer to real-world usage for colostomy and ileostomy use cases compared with water fill experiments. And that, of course, is what we're discussing at this moment. Mr. Bree agrees with that, we'll come to that, but he says that I don't get anything out of Pelican synthetic fill, but they won't tell me what the formula is. So the relevance of absolute and relative on my evidence go to my point 2, and my point 3 on the synthetic, that's the evidence we've just looked at. Then we need to turn forward to page 200, sorry, paragraph 267, which is page 71, where Ms. Anderson explains the modifications and what is to be got out of them. It's 267 and 268.
So you'd like us to read that?
Yes, please.
So where does she say that ModaVi gives you information about the waste only and not the lobes? At the moment, it would seem to me the other way around, because ModaVi has the lobes but no waste, and therefore gives you information about the lobes.
I've turned on, and I need to just go back to get it in front of me. Just give me a moment.
Particularly when you take into account the fact that, as she explains, the control is the prototype.
The control is
and so you then compare the mods with the control. And so mod A is waste only, so that tells you about the waste. Mod B is lobes only, so that tells you about the lobes. And mod C, you've got neither. And that tells the relevance of that, as she explains, is it tells you what the sea world is doing.
In my submission, that's not quite what she's saying. What I get out of 268 halfway through is picking it up on the paragraph, and the sentence starts, it can be seen in both the front and side view images that removing the waste in mods B and C has no real substantial or consistent effect on the deformation of the bag. So she's talking about the waste, and she's referring to mods B and C. She then goes on at the top of the next page to say, I note that some sagging is evidence when the waste has been removed in mods B and C. So every time she's talking about what she gets out of mods B and C.
Well, to be sure, but it's all framed in the negative. So what information do you get from removal of the waste?
Yes.
And if you remove the waste, the effects that you observed must be due to what is present, viz. The lobes.
In my submission, that depends on the experiment. If one, for example, were to look at the stability of a four-wheel drive car and one compares it with a front-wheel drive car, one is learning how the rear wheels contribute towards stability. And I say that it may depend on what experiment one is doing and what one is looking for, but in the way this has been introduced by our expert, it is what I get from mods B and, well, sorry, what I get from mods B is information about the waste by virtue of its removal, rather than information about the lobes by virtue of the fact they stay there.
I see.
I am getting short on time because I will need to, I think I will need to handle Ekin as well, and obviously I'll go on Grumshaws and costs. I will just say this, rather than take you to Mr. Bree's evidence, which I say is in agreement. It is in agreement, and just to give you the references, which are in the supplemental bundle, his first statement at pages 80 and 81, and he makes the point on absolute and relative, and it doesn't allow for reliable comparisons in para 257 of his report. And actually at 263, after making lots of other points, he says the conclusions from all of these issues is that the Pelican water fill results overall are unreliable. So the claimant's evidence was all our waterfall fill experiments were unreliable. So that's page 81 of the bundle. I'm going to move on to Ekin because I'm moving on to nuance on this point, and I don't have enough time to go into it in further detail. Ekin, I have 2 points. Reading the judgment, is he taking it into account at all? And it's not clear that he is. It's not clear, I've got to say, he's wrongly taking it into account. But in any event, what Ekin teaches needs to be interpreted by the skilled addressee, so you need to look at the expert evidence on that. Insofar as does he use it at all, I would look at the judgment, again at paragraph, look at the judgment again, this time at paragraph 92. He discusses the relevant parts of Ekin, and he says that at 96, I accept that Ekin is relevant and makes claims for the effects of the lobes and the waste. On their own, however, those claims don't show infringement. So it is not clear to me whether he's using it at all. On this point, what the others, I'm just going to give you a thumbnail sketch here. What the other side are saying is it shows channeling of waste towards the centre, which is more even and therefore is consistent with their inventive concept. That's what how they say it is to be read. Miss Anderson didn't give evidence on this because we didn't ask her to. We said Ekin wasn't relevant at all, a point on which we lost. And we don't challenge. Haven't challenged. Yeah. What did Mr. Bree say about the how he read Ekin? And it was really this point. When Ekin is talking about channeling of waste and even distribution on the wafer, it is talking about side to side, left to right, unevenness of waste accumulation. What the patent, or what the alleged inventive concept is even distribution top to bottom. So even if our bag does achieve the claim in Ekin, the claim in Ekin is horizontal even distribution. The inventive concept is vertical even distribution. They are different things. So one doesn't fulfill the other. That was the evidence of the claimant's expert on cross-examination. And that is what we say in a nutshell takes Ekin out of the picture. That cross-examination is in the supplemental bundle, and it is at page 237, hopefully. And can I ask your lordships to read the cross-examination, working now on the manuscript pages, from page 203, line 18, where I say, okay, just for a moment. And I put that idea of horizontal rather than vertical, and he answers, it can be understood like this, at 204, line 13. Yeah.
So we should read those.
Yes, please. So that's where I say Ekin comes in, and I say insofar as Ekin is relevant, their expert evidence shows that the claims made are not relevant because it's in the other plane. Final point then on my respondent's notice is the consistency point. It's back to the relative point. It's really a point that doesn't need the evidence. Everyone agrees it's a relative comparison, and it was wrong, we say in principle, for him to say, well, relatively it's different, and that's it. He didn't say, well, how small is small? Doesn't seem to be any gauging there. Before I move on,
I don't quite understand that point.
Well,
if it's an absolute comparison, then you can quantify it.
Right.
But if it's a relative comparison, then it's inevitably going to be a question of degree.
Yes.
Smaller, larger.
But
these are questions of degree.
There is nothing in the judgment that indicates, having said it's small, that he considers it's enough, or on what principles or basis he considers it's enough. I do want very briefly to address one other point before I go on to Grumshawson. And this was the allegation made in my learned friend's reply skeleton, and again in submissions to your lordship yesterday, about some form of lack of disclosure and some form of secret privileged experiments that we carried out that we did not disclose. It's quite a serious allegation, and I'm sure my learned friend didn't mean to mislead the court, but inadvertently it seems that he has. The footnote in my learned friend's reply skeleton refers to cross-examination of Mr. Mahood and said he admitted that. They then wouldn't even let us put that cross-examination in the supplemental bundle for your lordships to see, so it's in the unagreed bundle. But what Mr. Mahood says is excluded from the piece of PD is not some undefined secret or privileged experiments. It is the experiments that were in the notice of experiments. And he says, well, the PPD doesn't talk about the litigation experiments because they're in the litigation via the notice of experiments and the experts opining on them. And obviously the function of the PPD is not to comment upon them. And that was a footnote in the PPD to say, this is what we know about how they function. We haven't done any experiments. Footnote, except of course for the litigation experiments, and that's not a matter for the PPD, that's a matter elsewhere. But insofar as there's an allegation made of misfeasance and misfeasance admitted on cross-examination, that is just not the case. So I'll move on to Grumsh-Wilson. My Lord...
Just before you do that, can I just ask you a question about infringement and some of the evidence we've just been looking at? And I know that you say that, I think you say that part of the inventive concept is the idea of downward extending world components.
Yes, the inventive concept includes the way it's achieved.
The direction.
Yes. Yeah.
Now, it seems to have been common ground between the experts that nobody would put upward pointing ones, or even probably ones which were at a right angle to the periphery, because the effect of that would be to trap waste, which no one wants. Now, could it be said, well, it's therefore obvious to everyone that there's going to be some sloping element, at least on the upper side, because you've got to stop the trapping of waste. And that what really matters is, and what's the inventive concept, is the use of weld components to have this essentially narrowing effect on the bag. In other words, because no one would think of putting in a component which had an upward slope, it's so obvious that no one really needs to spell that out, and it's not part of the inventive concept.
I suspect that may be how the judge got to where he got to, why he took it out of one and put it in as an essential element in the other. However, there's two answers perhaps to that immediately occur. One is that the patent, for whatever reason, does claim a monopoly without downwardly in various instances. And that would be sort of inconsistent with proposition posited that one would always make them downwardly. That's one answer. The other answer, and it's something the judge picked up on, despite my not arguing it, and it's slightly reminiscent, it slightly comes as to the fact this started in the IPEG, and therefore one tries to narrow things down and not take every point. And what one does is one puts together a claims chart and you say integers, dun, 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 dun. The problem with being a defendant is the ones that you might admit, the other side then pushes the construction of the ones you didn't admit because you've sort of conceded the point. And what happens in claims 5 and 8 is the extensions are on the side and they go downwardly. And what the point I didn't take is that, of course, in our bag, actually, once one got to trial, rather than what one pleaded right at the beginning, the extension, the lobes aren't on the side, they're at the bottom. And that's what the judge held. The judge actually said, well, the lobes aren't actually on the side anyway, they're in the bottom. And of course, once one's contemplating the purpose of extensions on the side, that may be different to how you structure them than if you put them on the bottom. So it was sort of a point I didn't take that the judge found in my favour. That's the best answer I can give at the moment. Not that I have another opportunity. So, Grumshawson. Anything further? No. Lord Justice Arnold raised two types of novelty, explicit disclosure and inevitable result. We say this is an explicit disclosure, but you may need a bit of technical help to get there. Explicit disclosure is not how a lawyer reads the document, it's how the document is to be read by a person skilled in the art. Now, actually, when you read...
We've just seen the statement in Van der Leyden, which still remains good law, that it's a question for the court.
Yeah, yeah. But...
Once it's seized of the skilled person's competence and knowledge.
Yes. And actually, this is a disclosure that one can understand oneself, depending on how mechanically minded one is or not. But it's more helpful if the expert explains it. But one can obviously have technical input. The example I gave was, let's say there's a claim to a red light, and there's a prior disclosure of a light in which lambda lies between 625 and 740 nanometers. A trial judge may need explaining to him that lambda is what is used to measure the wavelength of light, and that 625 to 740 is red. Once he knows that, or she, it's an explicit disclosure that becomes an anticipation. But we actually say we don't need the expert evidence. Firstly, we say we don't need the expert evidence. I will explain it to you how it works now. Secondly, we still don't understand their explanation. Thirdly, if one did want to look at how the experts thought it worked, I cross-examined Mr. Bree on this, and he agreed I was right. So there is nothing in it. And the way it works can best be got from the supplemental bundle at page 163. I'm now going to go to something completely different. It's not there at all. Marvellous. Okay. Actually, I'm probably better off. That's perhaps for your record as to how it works. Perhaps I'm better off just explaining how it works. So Grumshawson is in the supplemental bundle somewhere. Where is it?
Tab 20, is it?
Tab 20. And let's look at figures 5, 6, 7 and 8, which explain how it folds up. Now, Grumshawson is a urostomy bag, although in the US, most colostomy bags are also drainable in this way because of the price of things in the US. So that's why it fell into potentially to being a colostomy bag within the meaning of the claims. And it has the bag element in which the waste collects, and we see that in figure 5. It's the surfaces 1 and 2. That is what is going to form the bag. And it also has a third layer at the top, 3, that is the comfort layer, which is a nicer, smoother, furrier layer that lies between the bag and the body. And the whole point about Grumshawson is that what you can do is you can fold up the outlet and you can pop it in a little pocket between the bag and the comfort layer so it doesn't protrude and it's not uncomfortable. And so you have members 10 and 11, and what that is sort of a clip at the bottom of the bag, perhaps shown best in figure 1. And when you're about to empty the bag because you've unfolded it, it is these resilient members 10 and 11 that are going to keep it closed. They're sort of springy members. But in use, when it's folded up, they're not what is going to form the bottom of the bag because you folded it up. And then the next set of little things one needs to look at is 5 and 6. And what 5 and 6 are is strips that are going to mate with each other to keep the folded up section in place within the comfort layer pocket. So those aren't going to form the bottom of the bag either. So what one does in figure 5 is one takes the bag and one takes a first fold. Now if one started filling it at this point, it's immediately apparent that the waste the bottom of the bag is the waste going all the way down to where the fold begins, which effectively is where the line coming out of 10 crosses the bottom layer 1. And then one folds it a second time, and one still sees that there is there's a hollow area of the bag which is at the right hand side. Now even though surfaces 1 and 2 are shown as being adjoined to each other, next to each other, that is still usable space of the bag until one gets to the fold. Because there's nothing stopping it being usable space of the bag until it gets to the fold. And then at figure 8, it's folded a third time. And again, although the two elements 1 and 2 are shown adjoining each other because there's nothing in the bag, any waste that fills the bag is able to flow all the way down to the extreme left-hand side of the sort of tower structure, the fold.
Well, that's
because it can.
That's your assertion, but we don't see it in the picture.
No.
And what we do see is that by contrast with figures 6 and 7, where there's a clear space shown for waste to flow down, in figure 8, by contrast, one sees the two surfaces apparently abutting.
Absolutely, absolutely. But these are schematic, diagrammatic. The patent, Grumshawson does not say where the space stops. This is why, and I didn't open with this because I didn't want to pick a fight I didn't need to pick or wasn't necessarily going to win. And is this inevitable result or is it explicit disclosure? There is no explicit disclosure as to where the waste can go. There is explicit disclosure as to how it works, from which one can work out where the waste will go. Is that an inevitable result of how you fold it, or is it an explicit disclosure? I don't really see that I have to go there. But what I say is it explains how this.
Sorry, you do have to tell me what your case is.
Yeah.
I mean, of course, there's nothing to stop you arguing the case in the alternative. But I would like to know, is your case one of explicit disclosure, or is it one of inevitable result, or are you somehow arguing it in the alternative?
I'm arguing that it's an unnecessary and perhaps in this context an unfair categorization. But I have to accept, if one is saying, is there explicit disclosure of how the bag would fill? Answer, no. Have to accept that. Is there explicit disclosure of the structure of the bag? Yes. Does that explicit disclosure go as far as explicitly teaching you as to how the bag would fill, or is it an inevitable result as to how the bag would fill? Perhaps I accept I want to ride both horses on that and run it in the alternative.
All right.
That is the explanation I've given you as to where the waste, how far the waste can go down. And my expert if it's explicit, if it's inevitable result, I can rely on what my expert says would be the inevitable result. Is as recorded in the judgment with the green line. That's what evidence came from my expert. I did put this to Mr. Bree on cross-examination. Before I take you there, I would say this. In chief, Mr. Bree just said, it's different. He didn't explain why. Didn't go into an explanation. It was a part of his report. In our understanding, it was a classic example of why the judge treated his written evidence with caution and likely being written by his lawyers and not his own work. In cross-examination, I put this explanation to him and he accepted it. And that again, I'm afraid, is in the unagreed bundle. And it's at page 194. I hope. And it's at page 222, bottom right, from line 23. And I say this, actually picking it up at 19, I want to talk about how the fold operates to stop waste coming out. That is correct. If I look at figure 8, that's figure 8 of Grum-Schwarzen that we've just looked at, let us leave to one side where it is at the moment. The thing that would stop waste coming out is where the first part of the folding over clockwise to the right occurs. Yes. That's really it.
What on earth does the first part of the folding over?
Well, what I say is that is the left-hand side where the green line goes to.
Green line. Where do I see the green line?
Sorry, the green line is that came from my expert's evidence that was reproduced in the judgment.
The simple way to have done it in cross-examination would have been to put the figure with the green line to the expert and get his agreement to it. Did you do that?
It's not on the transcript, so
the answer
no.
Right.
No. One of the difficulties with the cross-examination, just to digress a moment, is both the experts were desperate to refer to the bag itself, which we had under a notice of models in court. And we kept on spending our entire time telling them they couldn't do that because it had to be the document itself. And it even ended up in a sort of mild, one of those counsel asking too many questions, him not me, that our witness left the witness box when the judge was playing with the sample and showed him exactly where the bottom was. But of course, the transcript is only audio, not video, so we didn't get to see that.
I mean, there does seem to have been a question on page 224.
I should have read on. I did.
18, where you said, well, I'm sure you're aware Miss Anderson's evidence is that when it's folded up, obviously the closure can be much closer to the inward protrusions, but nonetheless, the mechanism we've gone through means there will be a cavity below the protrusions. There could be a gap, yes, but a very small one.
Yes.
So that seems to have been the punchline.
I should have read on. I do apologise. I was rushing on before the time, but yeah. Thank you for that, because I was in my original note said read on, but I skipped it. Right, costs. Costs, we say, are in the overall discretion of the court. There are some rules particular to IPEC, special cases, making costs for unreasonable behaviour at the end of applications, making costs for abuse of process. We're not alleging either of those things, never have, so they're not relevant. But we say, even outside of those, there is a general discretion. And we submit, it's long been accepted. Now, let's first, we do say it's worth looking at the general case for smaller claims, small claims court and transfer, which we put in the authorities bundle. Now, everyone just takes a step back. The purpose of the smaller claims procedure and the purpose of IPEC have similar purposes. It's to provide...
Well, it's got to be very careful with that statement, because IPEC has a small claims track itself.
Yes. Yes.
So the default in IPEC is multi-track, but you can have small claims track within IPEC.
Yeah. The point I'm getting to is the small claims, which is rather more perhaps used than IPEC, there are specific rules.
Yeah, but the whole point about IPEC is it's a bespoke regime.
Yes.
So how do you get anything out of the general regime on small claims, particularly when we're talking about a multi-track case?
I say that the rationale for both procedures is to provide affordable access to justice, and by doing so, to give the person who starts the case an affordable way in. And there's no difference in rationale between the small claims generally and the IPEC more specifically. The small claims has its own rules, and I only get this by analogy, that basically says if you bring something in the small claims that is transferred, presumably because it is not suitable for the small claims, the costs during the small claims track are at large for the trial judge to assess. The claimant should probably never have brought it there in the first place. Likewise,
well, can you just show us what you're referring to there?
Sorry, I'm hypothesizing a lot, but I am working from the CPR in Authorities Bundle, tab 2, page 6. And it's CPR 2715.
Right, and where do you find that rule in the IPEC?
You don't.
So might one not say that the absence of that rule in the IPEC rules tell you that the intention for IPEC is different?
One might say that, but I would reject that submission on the basis, without going through all the working papers that set up smaller claims and all the working papers set up IPEC, is my proposition at the outset that the purpose of these tracks is to provide affordable access to justice for a claimant. But if they start in the wrong court or get transferred, these are consequences that follows. The rationale for the small claims track and the rationale for IPEC are effectively the same rationale, and we say it would be unusual or certainly illogical for there to be entirely different default costs positions. That's all I get out of it. I'm going to move on because I haven't brought all the necessary material to say, here's the working party report showing rationale for small claims, here's the working party report for IPEC. But we say that the system that logically follows from reallocation in small claims where either a claimant has brought a case which is unsuitable, gets transferred and therefore has to be subject to High Court costs, or a claimant has unwisely brought a claim that is suitable and then been transferred from the High Court to the smaller claims and so gets the small claims protection, should also logically follow in the IPEG. And there is no logical reason elsewhere other than to say, well, there isn't an express rule. We also say that there's no authority on me, directly on the board, but it has certainly been assumed that at the time of transfer, the transferring judge can either make an order that everything so far should be capped, which would bind the trial judge, everything so far shouldn't be capped, which is what I asked His Honour Judge Hakon to do, and he didn't, or he can pick some other option, which is actually what the judge did. Now, as part of the submissions, I would just like to look briefly at the Comic Enterprises case. That is in the authorities bundle, again, at tab 7. Now, this was an early case in the Pattons County Court, as was, that became the IPAG. And it was shortly after His Honour Judge Burse, as he then was appointed and was making his way as to how this court is going to work going forward. And he was asked to transfer a case from the PCC to the High Court. And what he said is this, at paragraph 57. I will add, it's the last paragraph of the judgment, I will also include a further term in the order for transfer pursuant to PD 30, para 9.21, namely the costs incurred in these proceedings prior to transfer will be assessed in accordance with the PCC scale in any event. Such an order is not appropriate in every case, but is appropriate here. And he sets out why. So what that judge certainly...
Does he give any reasons for saying it's not appropriate in every case?
No. He just does it. But what we say this shows, and of course your lordships don't have to follow this, what this shows is that, and it's the only decision of any direct relevance we've been able to find, is that it has long been considered that the transferring judge can decide what to do about costs, because they may be at large once we get to the end of the case. Now, what His Honour Judge Hakon did is he didn't make an order saying the costs ought to be confined. He didn't make an order saying the costs ought not to be confined. He made a somewhat unusual order in my submission, and that's not intended as a slur in any way. And he said this, he said, in my view, costs ought to be confined to the scale costs, but I'm leaving it up to the trial judge. So the order made by His Honour Judge Hakon clearly contemplated that costs remained at large, although he made very clear what he thought. And we say in that scenario, Mr. Carrere, sitting as a deputy, who looked at what His Honour Judge Hakon had said, it's recorded in his judgment that he definitely looked at the indication, but said, costs have been reserved for me. I can, of course, take into account everything that's happened subsequently. And this is what I'm going to do.
Would you accept that the appropriate way to exercise the discretion, assuming he was exists at all in those circumstances would be to start with what His Honour Judge Haken thought was appropriate, and if departing from it, to give reasons from doing so.
Well, I have some difficulty understanding the grounds of appeal, whether the grounds of appeal say that the judge had no discretion to depart, which seems to be the way the appeal has been advanced, or whether the ground of appeal is the judge did have discretion but exercised it wrongly.
I think it's put both ways.
Well, in my submission, it's actually only been put the first way. But if one is putting it the second way, we say that no relevant or nothing has been said as to why. Just give me a moment.
Sorry, you seem to have answered my question by answering an anterior question, which may well be relevant, but I'm still interested in the answer to the question that I actually asked. So let us assume that it is within the scope of the appeal to consider the way in which discretion was exercised. So we assume, for the purposes of my question, that there is indeed a discretion, contrary to the argument that there's none. Okay? So assuming Mr. Correct had a discretion to exercise, what do you say is the proposition that his starting point for the exercise of his discretion should have been what Judge Haken said, and if he was going to depart from it, he needed to give reasons for departing from
Well, that was what I understood your Lordship's question to be, and I was intending to answer that. My difficulty was I couldn't find the judgment, and I wanted to take you to the judgment so we could all see what he actually did.
it. Right.
And that is, now I've found it, at core tab 17. And what he seems to do is this. At 17, at paragraph 17, the first thing he does, he says, a further point that arose for discussion is the treatment of costs that were incurred in IPEC before the case was transferred. The order of His Honour Judge Haken of 11 July transferring the case contains the recital. So as my Lord Justice Arnold said, his starting point was the recital. So he clearly got that right. He then looked at the what the judge at that time had said about the claimant's behaviour to date. He then considered whether or not the argument put that there was no jurisdiction for him to make it, and he went to the Comic Enterprises case. But he says this. The work, it says this at 22, why he departed. The work that I understand took place in the IPEC phase formed an integral part of a significant dispute in the patents case. In this case, the defendant had successfully defended the claim and should be entitled to recover its costs of doing in the court in which the matter was determined. So that's where he got to. I say implicit in that is the fact that this was, from the outset, run as a High Court case. Every point that could be thought of was taken. And it was pursued as a High Court case. There was no behaviour throughout. And it's not just His Honour Judge Haken who criticised the claimant's behaviour. They were criticised in the CMC by Mr. Justice Mead. They were criticised by Deputy High Court Judge Stone on an application made shortly before trial.
Once it got in the High Court is irrelevant to this question because we're concerned with the pre-transfer costs.
Well, the work that was done pre-transfer formed an integral part of what was fought in the patents court at trial. All the multiple points...
Sorry, we seem to be getting way off the question. So it seems to me the relevant paragraph is paragraph 21, because what he says in that is that Judge Haycon he says in the third line, his indication in a recital, I think it should be of his order, of reservation of costs was to give the trial judge discretion in that matter. And so he proceeds on that basis.
Yeah.
He doesn't make any reference to the Judge Haycon having expressed the view that there should not be an order for costs off scale. Still less does he give any reasons for departing from that view, does he?
Well, he definitely knew about it because he recites it in paragraph 17.
To be sure. But, okay, so if your submission is that he does give reasons for departing from that view, where do we find them?
Well, I've done the best I can in extracting, but I can't say he says, I am departing from that provisional view for these three reasons. He doesn't say that. I will say one further thing on the context, which may or may not factor in, is that one of the things my learned friend emphasised in opening was that we were running far too much prior art. And we didn't narrow down until an early stage. And where my Lord Justice Arnold may be going is thinking, well, why should you get the costs of that back? And that comes out of the equation anyway because of the order made at the CMC that we weren't entitled to that in any event. So a chunk of the work in IPEC has already been discounted. And the judge does refer to that earlier on in his judgment. If your lordships are planning to re-exercise the discretion because there is no indication from Deputy High Court Judge Carrett as to how he exercised it, it's really the points I make in the skeleton on transfer, but also the subsequent points is throughout, and this appears in Mr. David Stone's judgment, throughout the claimant has run this as a High Court case. There were experiments. The inventive concept, as pleaded in IPEC, bore no resemblance to the one that was advanced before the trial court. It was amended twice since then. And throughout, that there were, the other side refused even to plead what they meant by extends away or downwardly. They basically said this is a matter of expert evidence, and we're not going to tell you. And we didn't find out until I read my learned friend's skeleton argument for trial. And every judge who has heard this case has indicated issues with the behaviour of the claimant. And those are generally in the unagreed bundle because they wouldn't agree to let them in because they didn't want your lordships reading them as they might go to discretion. Sorry, I'm beginning to make pejorative points that are not probably helpful. I can't go any further on costs, save as to say that Mr. Carrett was in a difficult position because the judge transferring the case seemed to have made an unusual order in saying, this is what I think, but I'm not going to order it, and I'm going to leave it to you. And in that context, it can only have been His Honour Judge Haycon's, we say, thinking that how the case subsequently progressed would be something for the trial judge to factor in.
That, because as I pointed out to Mr. Campbell yesterday, we don't seem to have in the bundles a transcript of Judge Haycon's judgment on costs. We've got the judgment on transfer, which is not the material judgment for this purpose. We don't seem to have a transcript of his judgment on the costs.
My recollection, and I didn't check the point, because I was counsel in that, as was my own friend Mr. Austin. My recollection is that there wasn't a reasoned judgment. It was a one-liner, I've heard you all and this is what I'm going to do. That's my recollection, but I don't stand off it because I haven't checked that and it was some time ago.
Right.
Unless I can assist your lordships further.
Thank you very much.
Obliged.
Mr. Campbell.
Yes, my lords, in reply, could I start with a practical matter about timing? Now, I know this was down for a day and a half. I expect to inquire if my lords wish to impose a guillotine or not. And before my lords answer that question, could I just say a little bit more? If I ran through my note as it is, I would estimate about 40 minutes. My learned friend Mr. Austin thinks less than 5. But there were a number of points there that were new and we've not really had a chance to look through them. So with those in mind, what would my lords be proposing as regards to timing?
Let me just confer. Mr. Campbell, firm guillotine is 1:15.
Thank you very much. In general, my lords, I'll reply to my learned friend in the order of points he made. My overarching point is that many of the points made by my learned friend were new, in the sense they weren't in his respondent's notice or skeleton, and some of these I will address. In fact, I will address them all as best I can. But some of them do involve unfairness to my client, and I'll say why that's the case. Now, my learned friend started by submitting, and I have an electronic copy of the transcript. I don't know if my lords do, but I'm not going to go to it. I'm just going to read out with a reference as to what I do. He started by submitting, and this is yesterday, 142, lines 17 to 18, quotes, "It is relatively complex fluid mechanics as to how that substance flows and therefore fills the bag." And at page 143, he said, quotes, "There is no evidence that the extensions in the patent will be understood by the skilled addressee reading the patent as having a directing or sliding effect. No evidence of that at all." And at page 145, the learned friend said again about directing or sliding functionality of the fingers. He said the defendant's experts cross-examined on the point and holds firm it is just to stop trapping, it is not to direct them. So that's quite a lot about complex fluid mechanics and how the weld portions are not to direct or not have a directing or sliding effect. Now, in support of his submissions about that, he went to where he mentioned a passage of transcript, and my Lord Justice Newey suggested we look it up, which we did. And as I think my Lord Justice Arnold noticed, Miss Anderson did talk about the sliding effect in that very passage. And I'll just take my lords to that to remind you, because this one is worth looking at. Sup Bundle, tab 18, page 244. And if my lords have page 244, the question at the bottom, line 24, I'm just saying, in order to provide the reduced bulging and reduced sagging you mentioned, and you accept they provide, the important point, or an important point at least, is whether they project inwards and downwards from what would otherwise be the periphery of the bag. Answer, I do not think that's what makes it fall, whether they're going down 90%. The reason why they're going down is for the waste to go downward, not to get trapped. That is the only reason why they're going downwards. I think they would have the same effect if they were 90 degrees in the back. It would just trap the out on the side. So that is the reason why we want it to slide down. And she actually makes a point about lines 16 to 18. I think it's important for the way the bag works that they go downwards, because otherwise the waste would not go to the bottom. Which my submission doesn't use the word directing, but it's the same point. Now, this was the high point of my friend's evidence in support of his proposition. There was no evidence the skilled addressee would understand the extensions having a directing or sliding effect, and we see that Miss Anderson herself actually accepts that expressly. Now, This also seems to be the high point of my learned friend's evidence on what he calls the relatively complex fluid mechanics. No other evidence was mentioned. But as regards sliding, I mean, how else does one get, how else one does arrive at the diagram that was agreed that Miss Anderson produced? My learned friend also sought to criticise Mr. Bree as a witness, both yesterday and today. There's nothing in this criticism. The judge held at paragraph 24 of the judgment that Mr. Bree was doing his best to assist the court. There were some reservations about his written evidence, but that all turned out in a single word, buckling, which has had very little importance on this appeal. But in any event, even if there was criticism of his written evidence, the technical explanation as to how the weld portions of the patent work to provide the claimed effects was agreed. Now, then we had the first of several references to the unagreed bundle, but it turned out all my learned friend wanted out of it was reference to some inadmissible evidence about what Miss Anderson thought ordinary English words meant. Of course, she's not even a native English speaker. For instance, page 35 of the unagreed bundle, I'm not going to go to it, was Miss Anderson's views about, quotes, finger-shaped, close quotes, welds, which is not part of the claim. Now, next, my learned friend spent some time on the protocol on the interpretation of Article 69 in the EPC as amended in 2000. I'm not sure where that submission really ended, because if my learned friend is seeking to suggest that the Supreme Court's decision at Actavis is somehow inconsistent with the protocol, that would be a matter for the Supreme Court itself and not for this court. But it's not even correct, because Lord Newberger was careful to explain on a number of occasions that the Actavis approach is consistent with the protocol. This one is worth looking at. It's Authority 23. Page 41. And I'm not going to read the whole of this. I'm just going to direct my Lord's attention to two paragraphs. Paragraph 53 expressly refers to any patent system must strike a balance between the two competing factors referred to at the end of Article 1 of the protocol. And this is under the heading, the proper approach to infringement claims. And in paragraph 54, for instance, Lord Newberger expressly considers both Article 2 and Article 1. Lawyers will see a reference about halfway down. Such an approach complies with Article 2 of the protocol and also with Article 1. Now, there are other references, but there's no support from a learned friend's submission that Actavis doesn't have due regard to the protocol. On the contrary, that was expressly considered. My learned friend also spent some time on Catnick. In my submission, that was interesting, but of no assistance, because as paragraph 54 of Actavis makes clear, and as Lord Kitchen said in Icegate, Catnick is the old approach and Actavis is new. Lord Kitchen said the new approach was, quotes, markedly different to Catnick. And I showed my Lords that yesterday, paragraph 59, page 317. And Catnick didn't even establish any presumption under the old law, let alone under Actavis question 3 of the new law. My learned friend then made a point about how this was a, quote, very, very, very unusual patent with 3 varies. That was page 159 of the transcript. He says it's the only granted UK patent he had seen with multiple independent product claims. Now, not only is that a new point, but it is a new factual allegation for which my learned friend didn't offer any support. He didn't rely on any evidence of figures showing how many patents had multiple independent product claims. Now, in my experience, what it's worth, and I don't think this is evidence, I would agree with Lord Justice Arnold on this, that 10 is unusual, but multiple is not at all unusual, multiple product claims. And it would be unfair on my clients, I would suggest, to assume it is factually correct that this is a very, very, very unusual patent. And of course, my learned friend's argument that you have to construe one independent claim by reference to another independent claim doesn't require 10 claims. It runs when he's got as little as 2. And such patents are not so rare in my submission that this can be assumed to the reason why there is no authority supporting a learned friend. We then have a learned friend's having it both ways points, And these were his words, not mine. In particular, my learned friend sought to have it both ways by saying that extension away appears in every one of the 10 independent claims, so it's important. And the fact that downwards only appears in some of the claims is also important. From which it appears to follow you can't conclude anything about claim X from looking at claim Y. Because of my learned friend's argument, if they contain the same features, that's important. But if the opposite is true, they don't contain the same features, that is also important. So my learned friend's argument, we would suggest, could be used, and indeed is being used, to justify whatever answer one wants. Another reason why it's a bad approach in principle. My learned friend also said a number of times it was too difficult to identify the inventive concept. We don't accept that's factually correct. Both experts understood how the well portions of the patent works. And my learned friend's defence and counterclaim at paragraph 10 shows that he was able to produce an inventive concept, and it's very similar to ours and the judges, save perhaps for the word downwardly. I also note there was never any allegation the patent was insufficient in that it did not disclose the invention clearly and completely enough for it to be performed by a person skilled in the art. So for all these reasons, it was not too difficult for a learned friend to identify the inventive concept. The learned friend drew attention both yesterday and today to the fact that our pleading on inventive concept was amended twice. He didn't show them to you, because then he would have had to explain why he thought they were materially different, which in our submission they were not. And so what anyway? We were not criticised for having 3 versions by the judge, and there's nothing in the respondent's notice of skeleton argument making that point either. We do note, however, the judge noted and felt it necessary to note there were 3 versions of the PPD. That's judgment paragraph 9. Now, my learned friend sought to rely on paragraph 103 of our closing below, which he suggested was a concession. This we should look at. It's supplemental bundle, tab 13, page 97.
One 197.
197, yes, I was just checking. That must be wrong. Yes, I'm good. It's not a concession at all, and was never read by my learned friend that way until very recently, certainly after the skeleton argument, perhaps the last few days. Now, just read what it does say. Para 102, this is Salt's inventive concept, starts at part 102. Miss Anderson understood the effect arise because the well portions make the bag narrower. In a sense, this is the effect of the well portions because they protrude in some way towards the centre line of the bag. 103, therefore, in other words, following from 102, a bag that is narrower, for example, by the inclusion of a narrowing waist, works in the same way as the well portions of the patent. We return to this point further below in a discussion of infringement under the doctrine of equivalence. Now, this part of our closing is obviously running with what Ms. Anderson has said, and we can see from the reference to the doctrine of equivalence that it's focusing on the waist of the ModaVi, not any old waist. And it's certainly not talking about the common general knowledge at all. Learned friend's point, which he failed to make clear, was that his position was that this statement about the effect of the waist of the ModaVi was factually wrong. His position, as set out in the PPD signing the statement of truth by Mr. Marhood, was, and I quote from paragraph 2.7.4, reproduced in the judgment of 66, the waist facilitates the comfortable folding of the pouch as shown in figure 7. But my lords may think it's more significant that if my learned friend had any time before the last few days understood paragraph 103 to be a concession on an inventive step, then the whole of the first instance judgment and the nature of this appeal would have been very different. In particular, my learned friend would have made the point he now seeks to make, namely that he says paragraph 103 is a concession, that our formulation of inventive concept reads onto the prior art, because he would have had every reason to make that point, because then he would have won on validity. But he never said that to the trial judge, made that point as respondent's notice, or at any point in his 26-page skeleton argument. In addition, my learned friend, if he'd taken this as a concession, would presumably have reformulated his own version of the inventive concept to take advantage of this alleged concession. But he didn't do that either. In fact, just to cap it all, my Lord's, the interest is known, my learned friend accepted this was not a concession made. If my Lords go to core bundle, page 81, we'll pick it up at page 80. This is Octavia's third question, but my learned friend's position is the third and third question. First and third questions overlap. 91, never mind what the judge was right to find, but it's a quote from the judge. As he correctly observed, the invention can be achieved in a number of ways. For example, as Salts put it in closing, by making a narrower bag. In this case, the patentee has chosen a particular way in which to achieve. And then footnote 47. Footnote 47 says the reference here to Salts is an error. It was Pelican who made this point. So if it ever occurred to my learned friend that Para 103 was us making a concession that making a narrower bag was a way to achieve the invention, he went to footnote 47 saying, no, it wasn't Salts that made that point, it was Pelican instead. My learned friend also suggested that this was somehow supported by the judge's finding about figure-of-8 bags. He didn't explain what he meant by that, but I did touch on this yesterday. And it is worth looking at judgment paragraph 29 on core bundle, page 120. Core bundle, page 120, and para 129 is where the judge sets out various shapes of ostomy bags. Now, it will be noted that bag 5, for instance, in the top row, that is an example of a narrower bag, but that has nothing to do with the invention. So merely making a narrower bag doesn't tell you anything about weld portions. Figure 9 was relied on to some extent by my learned friend, but as the judge says, shape 9 is a figure-of-8 shape. Various commercial products are of the shape, such as the Convatec Esteem. My learned friend had an argument of validity attack based on the Convatec Esteem, which he expressly abandoned, although not until our expert had explained that the Convatec Esteem didn't have a waste at all within the meaning of the patent. So all in all, if my learned friend had thought that paragraph 103 of our closing was the answer to his prayers, he would have said so long before yesterday. Now, learned friend was also asked by my Lord Justice Arnold about his failure to plead any common general knowledge squeeze at trial. And yesterday, page 15694, my learned friend says I did actually plead that point going to Octavius 3. That's not factually correct. I'm not going to go there given the time, but para 16 of the learned friend's re-amended defence and counterclaim, core 15, page 179, says nothing at all about common general knowledge. It merely makes the same point about relying on other independent claims. Now, so far as this morning was concerned, my learned friend went to the facts of Acabia. Acabia. I'm probably going to mispronounce that. And he sought to draw an analogy.
Paragraph 18 of my re-amended pleading that makes
Paragraph
the allegation.
18. Okay, paragraph 18. Still nothing about common general knowledge. Page 73 of the authorities bundle is where I would say it's actually Octavius 3, page 79 of the authorities. So I might want to start at page 79. Now, in respect for submission, the reasoning of the Lord Justice Arnold at first instance in this section is very specific to the facts of Acabia. And really, there's no more than that. I mean, it's not an exercise in fact mapping. Learned friend did spend a bit of time on this. He said, well, it's all about structures, isn't it? But of course, Acabia was a chemical structure. And chemical structure has a very precise, well-defined meaning. And my Lord's turn back to page 73. habeas case, claim 17A was limited to that structure, compound C. And the whole point about chemical structures is that they're not at all the same sort of structure one has in this case. They are very precise by the definition. And in the caveat, my Lord Justice Arnold observed the claim was intended to be narrower than a general formula, because there had been amendment, for instance, and none of these facts apply here. So the caveat is a very useful illustration, but the facts are very different. Now, coming back to the judgments, my learned friend spent some time on para 129, where the judge deals with the Tavis third question. I've said pretty much everything I intend to say about this, but I did say, I did take issue with the judge's view that it would, for example, have been straightforward for the patentee to formulate a claim by result. And my learned friend didn't give an example of how straightforward that would have been. In our submission, it would not be at all straightforward. So far as construction is concerned, my learned friend, his submissions essentially went to the expert evidence for their views about ordinary English words, and that's not admissible in principle, particularly when it's not the native language. So, my respectful submission, we didn't really get any benefit from what the views of the expert about ordinary English words were. That was true from the start. But my learned friend did place some reliance on some points made by the judge. One of them was in para 116 of the judgment. Para 116 of the judgment, this is where the judge is dealing actually not with construction, but normal infringement. The judge found, third sentence, the purpose of the welds is to create a space within the periphery of the bag that channels the waste and also makes the bag narrower than it would be without the welds. Now that's two separate points there, but we say they both support infringement rather than being the reverse. And in para 117, my learned friend, he sought to proceed as though he sought to draw an analogy, which my Lord Justice Miles had already pointed out, between the direction of the red arrows, at least their construction, and the axes shown in figures 3 and 4. But of course, the claims are not drafted in terms of axes, so that's not really a helpful exercise to do. He took you to some cross-examination from the unagreed bundle when Mr. Bree was asked about the meaning of English words in my submission. That was not relevant. And also, my learned friend also referred to, but didn't turn up, para 147H of Ms. Anderson at SB page 99, and that doesn't even use the word axis either. My learned friend then went on to an ambitious attempt, which I think he himself accepted was ambitious in the light of iconics, to refight the battle on the judge's findings as regards the lobes. The starting point for this was a reference to the cases of Van der Lely and Thorn Security. But of course, all these establish is that the task of construing evidence, the task of assessing evidence, is a task for the court at the end of the day. My learned friend actually said, and I think my note is accurate, the mistake was the judge interpreted the experiments for himself. That's said to be a mistake. Well, who else was supposed to do that? And it's not as if the judge did so unaided by expert evidence. There was vast amounts of expert evidence on the experiments. And my learned friend said, and I think this part of the note is correct, he had no quarrel with the judge's analysis of the experiments. He just disagreed with the conclusion. Well, I'm afraid that's fatal. If you don't quarrel with the analysis, it's the same judge who's performing the analysis and making, drawing the conclusion. And the judge, he's well aware of the limitations of the experiments. He had 3 lots of experiments, of course, not just one. And the judge does appear to have found the defendant's experiments more helpful for infringement purposes. So maybe it was an own goal, but he had 3 sets of them. he was well aware they were not determinative, and he performed a value judgment. And in the short time available, Leonard Friends made points which, again, were new points. He said the judge failed to consider absolute and relative volumes, synthetic waste, water was not a good model, and why the various modifications were made. Now, it's true they were buried in the 365 pages of unagreed bundles, but we didn't know what they were relying on that for. And it actually turns out that if one goes to the unagreed bundle, one can see that they actually drew all these points to the judge's attention in their closing speech. So essentially, my learned friend is actually just trying to refight the same battle again, making all the same points. For instance, it's in the, yes, the unagreed bundle, page 350. As will be seen from paragraph 74, the learned friend was relying on all of the experiments. And he also relies not just on synthetic fill, but other ones. So that's why we say this really is just an attempt to refight the same battle as the learned friend lost. And the fact that we had to go to the unagreed bundle to get these points emphasises the point. As we mentioned in the skeleton argument, we wouldn't have been in the unagreed bundle in the first place because they would have been agreed. So essentially, the learned friend is simply making all the same points to this court in the hope of having a new trial and a different result. Now, the learned friends came to the C weld towards the end of his oral submissions and said, I believe this is what he said, it's common ground that the C weld works in the way we say it works. I don't believe, having taken instructions, that was common ground at all. My learned friend didn't give a reference for where that issue is said to have become common ground. And of course, I pointed out to my lords yesterday that Miss Anderson didn't realise that was the function of the C weld at all when she saw it. But so what anyway? So what if this C-shaped weld has an effect on bulging and sagging? Difficult to see how it could anyway, because the C-shaped weld's at the top of the bag and the bulging's happening at the bottom. But so what? That doesn't mean the waist and the lobes cease to have that effect. And we rely very much on the observations Lord Justice Arnold was putting to my learned friend about the experiments. Just because the defendants put this experiment in for one purpose didn't stop the judge noting, you're saying, for instance, the weight is absent, but that means the lobe is present. And the judge did exactly that. And that was the function of the judge, to make what he did at the experiment, rather than be bound by whatever the party putting in the experiments wanted to achieve.
Can I just ask you a question about the experiment?
Yes.
Is really the whole of the judge's reasoning on this point in 125? Because earlier on he does seem to have said that he didn't think, he said it was difficult to see anything which was really significant.
I'm not sure that's, I respectfully say that's not quite how he put it. He looked at the experiments and was able to assess there was some effect. But his point was, well, how do I know how big an effect is required by the patent? And he had 3 lots of experiments on which to base his views. And the finding at, I believe is it judgment 89?
89 seems to be about the patent.
I'm not sure that's actually right. He says they were helpful to demonstrate the behaviour of the bags in practice, but some of they're all alleged infringing bags.
But he doesn't say there anything specific about any of the defendant's bags. He then talks about the patent, or at least he says, hard to draw conclusions as to the significance of any of these measurements and observations in the context of the patent. It's not really clear exactly what that means. And then it seems as though it's 125, which is arguably just a very, very general conclusion about the ModaVi bag.
Well, it's obviously
Pretty
not.
tentative.
It's obviously experiments and Eakin, is what he's saying there. Sorry, in 126 he says experiments and Eakin. But just coming back to what my Lord says, and just looking at the way 89 is drafted, the experiments, now all of the experiments, the three sets of experiments, they're all in the alleged infringement. There are two sets of experiments in the alleged infringement, or rather prototypes we've created to mimic the effect of infringement. So they're all going to it, and what he says is none of them was decisive. Well, fine, they're not decisive, but the judge didn't decide the issue of infringement purely on the experiment. And then the last sentence, when he says hard to draw conclusions as to the significance, that's, I don't know what the yardstick is. I know what the experiments show, but I don't know what the, as I say, what the standard in the patent is. But he doesn't say it's impossible to draw conclusions. He says it's just hard. And then he does it. That's exactly what he does do in 125 and 126. So I respectfully submit there's nothing in Milan and Friend's criticism, and even if there was, if one looks at 126, it's not just the experiments. And I'm not going to go back over, but the experimental ModaVi bag, one can see with the naked eye what the judge was talking about. The lobes do have an effect in reducing the amount of sagging. But he refers to Eakin as well. And the only point I'd like to make on Eakin is that Milan Friend drew attention to some cross-examination. Milan Friend didn't go to anything in Eakin, any of the points I made, para 1, 5, what's Eakin aimed at, and he didn't go to paras 58 and 59 of Eakin, the judge's assessment of there. He just went to what Mr. Bree said in answer to a question, which I respectfully submit is extremely unclear. It's supplemental bundle, page 237.
And you've got time for this, have you, Mr. Campbell?
I'm sorry?
You've got time for this, have you? I think you're 5 minutes off your...
Time off. Okay.
No.
Right.
7 minutes if we go.
7 minutes. Yeah, 7 minutes. Well, Mr. Austin will have to do it in 2 minutes. Right. Well, there's this one then at one point in Grunschwanson. It's just this bit of transcript, which is sub-bundle page 237. And it really is, it starts at line 11, going back to just paragraph 1 again, and that's paragraph 1 of Eakin, and then reads it out. And then the question is, just for a moment, issue 2, this issue of pulling more on one side of a wafer than the other. If I assume the wafer is a sort of clock, the way I sort of read it is you might be putting it at 3 o'clock, you might put it at 9 o'clock, side to side, correct. If I contrast with what the patent is talking about, well, now Milan Friend's changed context. He's gone back to the patent in the suit. When it's talking about pulling at the wafer, I'll just read this to you for the moment. We do not necessarily go to it. And that is also, if you recall, we all recall, talks about pulling on the wafer. What that says at page 1 of the patent, and so on and so forth. And then, after this long, I would say, confusing question, do you accept the pull the patent is talking about, which is 12 o'clock at the top, up and down, is different to the pull that the Eakin application is talking about, which is side to side at 3 o'clock and 9 o'clock. It can be understood like this. Very charitable answer, because the question is not at all clear as to what's actually being asked. I mean, what is Milan and Friend calling the pulling at 3 o'clock to 9 o'clock, side to side in Eakin? He didn't go to Eakin itself in support of that. So all the witness is actually saying is it can be understood like this, whatever this means. And of course, it's not a different proposition anyway. It's just two different ways of controlling the direction of the waste. If Milan Friend's right at all about there's some difference between 3 and 9 o'clock and 12 o'clock, but if one reads Eakin itself, it's clear it is working exactly the same way as the patent. And finally, the last thing, in Grunschwanson, there really are just 2 points to this. As my Lord Justice Arnold got out of Milan and Friends, Milan and Friend didn't put to Mr. Bree, our expert, he didn't put the green line as shown in that diagram. What he did was, in my respectful submission, quite a confusing series of questions. And the end result of that is, quotes, could be a gap. So could be a gap in figure 8, sorry, in Grunschwanson when folded. So just analysing that, figure 8 of Groom-Schwensen shows there is no gap, and the witness is just saying, well, in real life, maybe there could be, but it could be, maybe not, but that's not what the disclosure of Groom-Schwensen is. And it certainly doesn't make a clear and unambiguous disclosure, just because the witness says it could be different in real life. So, Lords, I'm very grateful. That was pretty quick. I'll now give Mr. Austin a couple of minutes.
Yeah, thank you very much.
Thank you very much. I will, of course, try and keep this very quick. My learned friend referred first to the rules in the Small Claims Court, and I think I dealt with that point perhaps obliquely yesterday, which is that the IPEC costs, as I said yesterday, are a whole package of costs designed around the policy that was set out in the working group report, referred to in our skeleton, and that principle was repeated at paragraph 13 of the Westwood judgment of His Honour Judge Burse, as he was at that time. So we say the Small Claims Court rules are just completely irrelevant in these circumstances. Secondly, His Honour Judge Burse in Comic Enterprises, he of course didn't explain at the time what that order is. This order as to costs is not appropriate in every case, and we don't think it was argued, from as far as we can tell from the judgment. But nonetheless, a year earlier he had handed down judgment in the Westwood case, and a year later he handed down judgment in the Henderson case, both of which explained the interaction between the general discretion as to costs and the IPEC rules. And so I think we would say it's at least implicit, it was a fair assumption that what he really means is abuse of process, the exceptions for abuse of process under CPR 4620, or indeed for unreasonable behaviour under CPR 6326.1. So we say that means that the IPEC scale costs are the default position in such proceedings, and we also say that's the only realistic way to read the recital of the order in the order of His Honour Judge Haycon, not least because that recital was made in light of my learned friend's submissions at that time that scale costs should be disapplied, which we say was therefore an acceptance that the usual rules should apply absent any order to the contrary. Thus, we say in those circumstances it's quite understandable that the judge reserved the costs for the reasons discussed yesterday, simply no jurisdiction for him to determine costs at that stage, and the rules in the CPR as to transfer didn't help him in any sense in terms of encouraging to determine those costs up front rather than leave them to the trial judge. So we say ultimately my learned friend appears to rely on a mistaken characterisation of paragraph 21 of his Deputy Judge Carrett's judgment in this, and we don't think that's how the recital should be understood or read. And finally, my learned friend refers to the subsequent facts, in other words, the judgment of Mr. Justice Mead and that of, under our disclosure application, of Deputy Judge Mr. David Stone, which came later. Again, we just say this is entirely irrelevant. What happened at the Patents Court, CMC, before Mr. Justice Mead and before Judge Stone has nothing to do with the determination of costs in the IPEC, which had happened sometime before that. So we say future alleged unreasonable behaviour, abuse of process is irrelevant. So ultimately we come out with the same result as I explained yesterday.
And I think you're on time.
Just
thank you all very much. As you might expect, we're not going to give judgment here and now. You will get the draft in the normal way for you to comment on English and typing. That won't, of course, be an opportunity to re-argue the case. We'd be grateful if at the same stage you would seek to agree an order dealing with consequential matters. If there are points on which you can't agree, can we please have brief written submissions, and we'd expect to deal with the points in the order that we make. Finally, although I'm sure you're all very well aware of this, I ought to remind you of the importance of the embargo. There are still breaches of the embargo happening. If you think of anybody else who ought to see the judgment and draft, you need to come back to us. Otherwise, there will be a breach of the embargo, and that is taken seriously. But thank you again.
Court rise is able.